Well, we're on record today. We've had, I think, at the last count was 10 motions filed in this case prior to trial. We need to have a review at some point because the petition was filed in August. And we're anticipating a trial, 5-day trial in February. I've had the opportunity to talk with the attorneys ahead of this to try to get a feel for whether or not we'd be able to get through these motions today. There's too many of them, frankly. I think it's going to be too hard to make the record one which is useful given the number of appearances that we have from parties by Zoom and the number of issues that are raised here today. Even during our bench trial, despite our best efforts, I found that it was it wasn't very easy for everyone to speak without interrupting each other. So we need to be able to make a good record on these, and that's a lot of what we talked about at our sidebar before we got started, but I'll let the attorneys address anything else they might want to talk about for the record about that sidebar after appearances.
Good afternoon, Your Honor. Ariel Berger here as the guardian ad litem for the minor children.
Nastasia Thomas, counsel for the department, with co-counsel Mr. William Amadeo.
Good afternoon, Your Honor. William Amadeo, P76194. We're joined by our workers, Nikki Jones and Chelsea Grant. Would you both put your name on the record, please?
Chelsea Grant with the department.
Nikki Jones, CPS investigator with the department.
Good afternoon, Your Honor. Alex Lizahub appearing on behalf of the respondent, Matthew Higgins. And he is appearing also on Zoom for this hearing.
Okay, we're going to need you to either introduce him or ask him to introduce himself to verify that he can hear us and is actively participating.
Sure. If I could address him through the Zoom. Mr. Higgins, could you please indicate that you're on live with us on this Zoom hearing?
Yes, I am here.
We also have Miss Leanne Higgins, who I understand is the mother of the children who's joined us today as well. Thank you.
Yes, I'm here. Thank you.
Very good. All right, let's start with comments about our sidebar. Ms. Thomas or Mr. Amadeo, whoever wants to address that.
Thank you, Your Honor. From what I understand, we're going to move motions out to February 5th. Since there are, I believe, 10 motions, we're going to want to make a clean record on all those motions. If you do adjourn trial, it will be the week of May 6th to May 10th. And I guess there was one outstanding issue, Judge. I'll defer, obviously, to you. Do we need a Daubert hearing as well for the supposed expert for the respondent? I don't think that was established at our side, where everything else I think is an accurate recitation.
Would you like to address your position on requesting the adjournment of the trial?
Yes, Your Honor. It was actually Mr. Higgins' motion to adjourn the trial, and based on his representations that there's at least a box full of outstanding discovery which may be relevant, I will concur the adjournment is probably in the best interest of justice.
Comments, Mr. Lizahub?
Yes, Your Honor. Please, thank you. Yeah, I did a very detailed motion, indicated a number of grounds for the adjournment. And I do believe it's in the best interest of all concerned. There was an issue regarding my expert being able to testify in person was one of the things. The voluminous records that need to be reviewed. There's issues regarding my expert actually asked to look at the CAC interview transcript, which the court protective order does not specifically allow him to do that. So consequently, I filed a motion to allow that. So there's a delay in that for the hearing on February 5th. I believe I've adequately spelled it out, but I do think it's in the best interest of all involved. The children are with mom. The Wayne County Circuit Court, which has jurisdiction over custody and parenting time, has issued a court order suspending my client's parenting time. So there's no prejudice to the children who are at status quo with mom. And I'm interested in getting this adjournment. I think it would be in the best interests of all involved. As far as the Daubert hearing, we're talking about first doing the adjudication to determine whether or not there's jurisdiction to the extent the jury determines that there was a violation of the statute and that there is jurisdiction, then there would be a termination issue. At that point, whether the CAC is viable evidence would have to come under attack in a Daubert hearing, and but that's for a later date. And to the extent the jury goes our way, then there wouldn't be a termination issue. And we do not agree to combine the termination hearing with the jury trial, although it is allowed. We're not agreeing to that. So we want that segregated.
Any
Your Honor.
comments on the sidebar, Mr. Lizahu?
The sidebar, I
Anything that
agree,
you
Your
feel
Honor.
that anything that you feel that the record should reflect as a result of our discussion prior to assuming the record?
I believe that it was a productive sidebar, and I do agree with the court that a good record needs to be made, and that it will be made better that if all counsel appear in person for the February 5th, 2024 hearing at 9 o'clock. I think that's an excellent idea, actually, Your Honor. I appreciate it. It was your idea, and I think it's an excellent idea. Thank you.
Ms. Berger, comments on the sidebar and your position on the adjournment?
Yes, Your Honor, I am not in agreement with the adjournment. This matter has already been adjourned once from a several-day jury trial that was blocked out. The children's therapist reports that they are at a standstill and that they cannot progress any farther while we are at this current stage of our proceeding. They are anxious that they may have to testify if and when that happens, and they're unable to process any deeper trauma at this point because they're almost stuck here waiting for something to happen. So I would not be doing my job if I agreed to that again. I do not believe it to be in their best interest. I think that it's putting an ongoing strain on them. If nothing else, I still have to talk with them and have to repeatedly ask them if they want to see their father, if they want contact from him, and if they have had contact with him. So I'm not in agreement with adjourning the trial again for reasons related to any discovery. I think it's inappropriate that there has been documents floating around for several months now that have not been circulated. Certainly, even if there are thousands of pages, one scan at a time over the last 90 days, 60 days could have alleviated some of that stress. So I would also ask that we have an order for discovery at this point. I believe that the request for the adjournment, I don't know that I believe it or not. However, I find it very suspicious that we are nearing the 21-day mark listed in the statute that would provide for sanctions for not providing discovery when the request for adjournment is asked for. So I'm not in agreement. I would ask that we keep the current date, that we schedule another pretrial prior to that to address any of these motions if necessary. Thank you.
Thank you. I have some concerns about the adjournment and the outstanding discovery requests, especially considering the fact that we were here last time on a motion. Mr. Lizahu was here on a motion asking for discovery from the petitioners. And understanding that he also had discovery in his possession at that time that he had not produced. Part of what we discussed at the sidebar was the fact that he has had a box of documents that he demonstrated to us for a period of 2 months. So I do have significant concern that these delays and these motions and this failure to exchange discovery is intentional. And I'm going to signal that on the record now. The nature of the motions for discovery seem to be requests for information that is tangentially relevant at best. So here's what I'm gonna do. I'm going to allow the adjournment. I'm going to set February 5th, the entire day to hear these motions. And I'm gonna grant the request to adjourn the trial to May 6th through 10th. But if we find out that none of this evidence is relevant and that this has been an intentional attempt to delay proceedings, then there will be potentially sanctions awarded to petitioners, especially in light of the fact that, as Ms. Berger put it, everything is effectively at a standstill for these children until these issues have been resolved. And that includes, by the way, the prohibition between Mr. Lizahoop's client and the children having any communication. So he's asking for this adjournment. He's giving the reasons for the adjournment, which I think are somewhat his own fault. The bond between this parent and children obviously is affected by this, and those are his actions. So yes, I'm cautioning you that if it comes down to it where this is an issue, there will be potentially sanctions issued here. In the meantime, you will be required, Mr. Lizahoop, to turn over all documents to other counsel within the next 7 days. Any information that you intend to use or potentially use at trial, you'll need to turn over copies of that to fellow counsel within the next 7 days. If there can be any resolution to any of these motions or anything else comes up between now and February 5th, obviously you know where to find me in order to get that scheduled. We'll have to have a review. I'll also schedule that for the 5th. So we'll tackle the motions and the review as soon as we can. The case will have been open for 6 months at that point, and we need to have the review pursuant to our requirement to have a look at what's been happening with the services for the children. And we're at the 6-month mark, so we're going to do that. This is the second adjournment. It will be reflected as the second adjournment in the order. All other prior orders will remain in full force and effect. Are there any questions?
Your Honor, given that we are obligated to conclude all our disclosures regarding discovery, my question is it the representation of the petitioner's counsel that all of their materials have been provided to my office?
That's not a question for me, Mr. Lizahoop. This opportunity is if you have any questions about the directives that I just issued on the record.
No, Your Honor.
Thank you. Any other questions?
I just have one. Ms. Grant did provide a really thorough report for today's hearing. Would this court accept just a simple updated memo, or would you like another full report?
Updated memo would be, I'm sure, fine. It's less than a month, so if you could just give us a little supplement maybe on what's been happening since then.
Yep, I may have new monthly reports then to
Okay,
add for it as well.
thank you. Anything else?
No, thank you, Judge.
No.
All right.
Thank you, Your Honor.
Thank you.